Hello everyone, my name is Ajit, and today I am going to discuss the editorial of 30th December 2025. The article is Supreme Court rethink on Aravallis is welcome and it was much needed. So the Supreme Court's decision to stay its verdict of November 20, which redefined the extent of the Aravallis, is enormously reassuring. The definition had effectively shrunk the more than 650-kilometer ancient range to a few hills. It militated against a more than 2-decade-old jurisprudence in which the court had drawn on its expensive interpretation of forests in the Godvarman 1996 case to nudge often mining-friendly state governments in the Aravalli region, Rajasthan, Haryana and Delhi, to protect the hills. The court's demand for a definition of the Aravallis was of course grounded in a need to address a regulatory deficit. Last year it found that an inconsistent definition of the range was the major reason for the persistence of illegal quarrying. However, the Supreme Court's decision to accept the criteria proposed by a panel constituted by the Environment Ministry, only land forms at an elevation of 100 meters or more should be considered as part of the mountain system, invited controversy. Fears that this height filter would aggravate the ecological insecurity of the Aravallis triggered protests in Rajasthan. A series of reports in this newspaper pointed out that the new definition would diminish the ecological services of the Aravallis. On Monday, at a three-judge bench led by CGI Surikant took suo motu notice of the range of voices, including these newspapers, that urged the court to review its order. The decision to put the 100-meter rule in abeyance is a much needed course correction. So thank you.